presentation will be based on the following themes. First, principally, had the jury known what we now know, the jury would have had far more than a reasonable doubt about Jarvis Masters' guilt. Second, what we now know, what the referee found, what the Attorney General accepted, is that the state's case is founded on the testimony of two inveterate liars. Bobby Evans, the state's BGF expert, who the referee described as a spectacular liar. Rufus Willis, who the referee described as an inveterate liar, with selective memory, who would do anything to save his skin. What we also now know, based on the findings of the referee, is that the remaining piece of evidence against Masters, what the DA called the choke chain around his neck, two kites written by him, were probably not authored by him. And significantly, while the jury heard about Willis's gross misdescription of Masters, they couldn't tie it up to anything because they were not allowed to know that Willis's description closely described Harold Richardson, a BGF lieutenant who admitted his guilt, and the two principal roles charged against Jarvis Masters. This missing piece of evidence that the state had the wrong man has now been admitted without objection. And what we also know is that Jarvis Masters is at most an accessory after the fact. The punishment would be 2 years served by Mr. Masters, nearly a quarter century ago. My co-counsel, Mr. Andrian, will discuss that aspect of the case. And what we now know is that the case is founded on a massive Brady violation by James Hahn, Bobby Evans' handler, was an arm of the DA's investigation and prosecution. Yet the jury was not told that Mr. Evans was a paid government operative who had been used by his handlers 30 or 40 times. Nor were they told that he was the principal suspect in a San Francisco murder when he agreed to testify against Masters. I'd like to start with the defense case that was never heard, because I'd like to talk about Exhibit 54, which we've directed the court's attention to. It's an important exhibit, read in conjunction with Willis's preliminary hearing testimony. It provides compelling evidence that of Masters, that the state had the wrong man, and yet the referee's report simply ignores it. Plus, we did not get a chance to reply to respondents' arguments, response brief on this subject, so we need to do that now. Plus, the exhibit is under seal, which means we have to walk through it while we point out certain sections of it that we believe you should know about. It's under seal because it involves an inmate's detailed report of imminent attacks on prison staff and gives the names of potential murderers. You'll see it at the bottom of page 1, that huge paragraph, and also in the top half of page 2. Mr. Andrew will discuss some of those portions. And on the last page, Ms. Ballator, who later became the head of CDCR, reports that in her opinion the inmate's debriefing is reliable. The debriefing also has self-evident marks of reliability. If this information leaks out, the inmate becomes marked for death. Plus, in this case, the inmate says that there's a dirty cop, suggesting the possibility that it could leak out. And if this inmate's information proves false, he's placed back in the yard with the gang, and his life is at extreme risk. So he is highly motivated to provide only true information. These unredacted portions of this exhibit that you are now reading were not seen by trial counsel, nor were they part of the trial or appellate record, and the entire exhibit was excluded by the trial court. How this got excluded and how the trial counsel did not get to see it involved mistakes at many levels, but we don't need to go into those details because the important thing is that Exhibit 54 in its entirety was admitted without objection at the reference hearing, which makes all the difference in the world because Exhibit 54, read in conjunction with the preliminary hearing descriptions by Mr. Willis, points to the conclusion that the state has the wrong man. This denial of master's rights also became a principal issue on appeal. Well, this court ruled that the trial court's exclusion of the Ballator memo, which is what this is called, was not against Richardson's penal interest, but that ruling, this court ruled that the trial court's exclusion of the Ballator memo was not against Richardson's penal interest was questionable. It upheld the trial court's exercise of discretion on the ground that there were other factors that the trial court could possibly have relied upon. By the time of the reference hearing, however, the previously redacted portions of the report, which establishes its trustworthiness, were revealed, and the trustworthiness of the statements was not challenged by the state. The state, however, now claims in their respondent's brief, which is the point I wish to direct your attention to, because we didn't get a chance to respond to it. They argued that no objection was necessary because Exhibit 54's admissibility had been ruled on by the trial court, and that this ruling became res judicata. This argument completely fails. First, res judicata could have been the objection, but it was not made. It's too late to make it now. Second, Exhibit 54 is a different exhibit than the exhibit that the trial counsel saw, so there's no res judicata. Ultimately, the trial court's ruling wasn't based on reliability, so again there's no res judicata, and the citation for that is the reporter's transcript at 14,718 through 14,719. Next, the unredacted version also contains extensive information establishing its reliability. Had an objection been made on reliability grounds, we would have pointed out how this new information in Exhibit 54 clearly establishes its reliability. We didn't get that chance. Even more to the point, had the court ruled against us, we could have called Mr. Richardson. Thus, for purposes of this proceeding, the document is admitted, and the evidence admitted at the reference hearing, without objection, points to the conclusion that the state has the wrong man, and Mr. Henry will explain the significance of that. This brings us to the state's case. The state's case against Jarvis Masters solely rests upon three pillars. First, the testimony of Bobby Evans. Second, the second kite in Jarvis Masters' handwriting. I say the second kite because Willis said the first kite had nothing to do with the murder. And finally, the testimony of Rufus Willis. The referee's finding removes the first two of these pillars. The third pillar, the Willis testimony, remains standing, but only because the referee found itself on the horns of a dilemma, having to choose whether Willis had lied before or was lying now. The court instead said he was a chronic and habitual liar and found itself on the horns of a dilemma as to when he lied. The third pillar, in other words, remains standing because it's rotten to the core. Let me discuss the first pillar briefly about Mr. Evans. The referee found that Bobby Evans was a spectacular liar who lied at trial, and that's at pages 8 and 10 of the referee's report. The state, however, argues that the referee's finding that Evans was a spectacular liar who had lied at trial doesn't necessarily mean that his statements against Masters were necessarily lies. Clearly, this is, however, was what the referee meant. In our response brief, we also show that Masters and Evans couldn't have spoken to each other in September of 1985, the month Evans said they spoke. In addition, so the state says, well, this spectacular liar, well, he was just mistaken. Our response brief also shows, and this is at pages 6 to 7 of our 22 to 32 of our response brief, and notes 6 to 7, and also in Petitioner's Exhibit 16, that statistically, based on the prison records, there's more than 99% certainty that the alleged meeting never took place. So yes, this spectacular liar is totally removed from the state's case, and Mr. Andren will discuss the significance of that. The second pillar of the state's case were the kites in Masters' handwriting. The DA described them as the choke chain around Mr. Masters' neck. But the referee found that Dr. Leonard's testimony that the kites were probably not authored by Mr. Masters was convincing, and that no opposing expert was offered by the state. Thus, the choke chain is removed from Mr. Masters' neck, and yes, 2/3 of the state's case is completely extinguished. And again, my co-counsel will discuss the significance of that. The third and final pillar of the state's case presents probably the most interesting legal questions. The referee found that Willis was an inveterate liar with selective memory who would do anything to save his skin. But as I said, the referee found itself on the horns of a dilemma, which I would suggest is a false dilemma. Because the referee did not take the final step, the referee failed to apply the weight of the evidence test. And because the referee failed to do this, per this court's decisions in Ray Larson, well, per the decisions in Ray Larson and in Ray Marriage of Eggers, independent reviews applies, which is a failure to take the necessary step, which means that independent review applies in this court, takes those 2 steps. The first issue is the false evidence issue under 1473. The false evidence issue is not whether Willis's recantation is true, but whether the weight of the evidence that he provided false and misleading testimony tilts in our favor. We have more than satisfied that burden. Our evidence is the only weight on the scale. We start with the referee's finding that Willis is an inveterate liar with a selective memory who will say do anything to save his skin. That's a heavy weight on the Masters side of the scale. We also have evidence that Willis probably lied about the kites. Another huge weight on Masters' side of the scale. To Exhibit 54, we have evidence that the man he described as was actually Harold Richardson, which means again that Willis lied. Another weight on the Masters' side of the scale. We also have the referee's finding that Willis will say or do anything, which means that when he's trying to save his skin, which means that he's probably lying when he gives state's evidence. A fourth heavy weight on the Masters' side of the scale. Our investigators, by contrast, had nothing to offer Willis. His admissions were against his penal interest. A fifth heavy weight on the Masters' side of the scale. And unlike his testimony...
Can I stop you to just ask, isn't it also true that the referee here found that all of these people had a motivation to lie now?
Yes, the referee found that. And of course, that would be considered in balancing the scales.
So how are we supposed to evaluate that then? I mean, you have this finding that there are these recantations and inconsistencies, but the referee also says that none of these people are credible, including their present testimony offered at the reference hearing. You choose to focus on the trial testimony being undermined, but the referee, in the face of the referee's finding, it's a bit tough, I think, for this court now to credit the recantations. All that can be concluded, I guess, from the referee's report is that all of these individuals lie then, now, and throughout.
Well,
so how do we sort that out?
Well, I would suggest we sort that out by applying the weight of the evidence test, and that's why I am going through it point by point as to the weight on the master side of the scale. Here in this particular issue, you've said yes. I can understand why an inmate could be motivated to lie for another inmate. However, on the other side of on the other hand, we have a situation where it's against his penal interest, because one, if he can lose his deal and then be guilty, or he's already admitted his guilt, then be subject to the death penalty. And two, he wants to get out on parole, and while we had nothing to offer him from our end, whereas the state had a lot more to offer him. So again, I would say that there is more evidence on our side of the scale, and the issue is, what I'm trying to make, the issue is not whether his recantation is true. That's not the issue under 1473. The question is, was false evidence introduced? In this case, we have the kite evidence, we have the Exhibit 54 evidence, we have the, and there's also the fact that, unlike his testimony for the state, which has 6 or 7 versions, and that's pointed out at page 127 through 130 of our exceptions brief, his 2001 declaration, which he twice verified and initialed, is corroborated by overwhelming evidence in the record, which we discussed at pages 107 through 122. And that is weight on the master side of the scale. And what do we have on the state side of the scale? Aside from the point you just mentioned, which is a valid consideration. We have a phone conversation with the deputy. Again, where Willis is seeking to save his skin, and where much of what he said conflicts with what he said between 1985 and 1989. And that's discussed in pages 127 through 130 of our exceptions brief. By way of example, asked how many BGF yard meetings there were before they hit. Willis told the deputy 6 or 7. Between 1985 and 1989, however, he said variously 1, 2, 3, 4, or 5. So that goes to the credibility of all his testimony. As I said, our point is that he lied at trial. Not to say that he's necessarily telling the truth now. There's no horn. The horn of the dilemma is a false dilemma. And again, asked who picked Andre Johnson for the move. Willis said Jarvis Masters. But between 1985 and 1989, he gave 5 entirely different versions. But never said Masters picked Andre Johnson. So, I believe, fairly considered, the weight is heavily on our side. Mr. Andrian will discuss how Willis would have fared as a witness had the jury known what we know today about this evidence. There's also the referee's failure to apply the new evidence test, which is not entirely the referee's fault because the law has changed. Under the current standard, the question is whether the entire body of this new Willis evidence would have more likely than not changed the outcome of trial. We clearly satisfied this requirement. Had the jury heard the entire body of the Willis evidence, the jury would have concluded, the jury would not have believed the word of Willis's testimony. But the Attorney General says, hey, you can't do that. You have to prove your new evidence is credible, because that's one of the statutory elements of new evidence. But the language of the statute doesn't mean we have to prove that an inveterate liar is credible. The referee found that our 2 investigators were credible. The referee also found that our kite evidence was convincing. That's credible evidence. The referee also admitted evidence that the state had the wrong man, which again means that Willis lied. The totality of evidence we introduced also resulted in a highly credible evidence that nothing that comes out of Willis' mouth should be believed. So yes, we're entitled to ask whether the jury would have had reasonable doubt about Willis' testimony had they known what we now know.
I love you.
And we know that the answer is yes. And this is more than simply about reasonable doubt. Mr. Mass's constitutional rights were violated. The state failed to disclose that their corroboration witness, their spectacular liar, was a paid government operative. The state also failed to disclose that their spectacular liar was handled by a member of the prosecution team. And we provide the details of that at the exceptions brief at pages 169 through 175. The law cannot give Mr. Masters back a quarter-century of his life taken from him. But we ask that this kind of justice be ended. We respectfully request that the writ of habeas corpus issue.
Thank you, Mr. Baxter.
Thank you.
Your Honor, Associate Justices. My name is Chris Andrian, and I didn't play a major role in a lot of the briefing and all of those things, but I probably remember I was the lead counsel at the habeas hearing. And as it came time for a closing argument, I sat down with the guys and we started talking about it. I said, you know, I think what I need, the role I need to play and the role I'd like to play for you today is to put you in the shoes of a trial lawyer like myself, somebody who's been trying cases for over 46 years now. And I'm an experienced trial lawyer, and I've had a chance to kind of take all of this in and take another look and say to you, if the state of the record, if we look at the state of the record as it is right now, has the presentation of false evidence, new evidence, led to the likelihood of a different outcome at the trial? And I'm going to say the answer is unequivocally yes. And let me tell you why. And I think the way you have to look at this is take all of these different things that Mr. Baxter was talking about and say we have a new stage. The stage has been reset. And maybe no one of these things, for instance, Justice Chu, you made reference to the fact of, that Judge Referee Duryea said, well, they're lying then, they're lying now, they were lying then. I think there's ways that you resolve that. As a trial lawyer, you're often faced with black and white. So if you have black and white, how do you decide? Well, you look at the other evidence and see what helps you decide whether it's black or white. So in this case, we have Mr. Willis's recantation. And I'll submit to you that that's all we have, and he says something different. By itself, that's generally not going to do the trick. I acknowledge that. But let's look at, first of all, his trial testimony, as Mr. Baxter pointed out. Now, I'm getting this case now. I'm looking at this case. How's this record? His trial testimony clearly was riddled with inconsistencies, as some of which Mr. Baxter pointed out. I, as a trial lawyer, could say that. Look at all those inconsistencies. When he was interviewed by our investigators in early 2000, he had nothing to gain by speaking to us and everything to lose, because we couldn't provide him anything at that point. But if he was going to come forward and say, you know, I didn't tell the truth then he's risking his deal. He's risking immunity. He's possibly subject to perjury. Then he is corroborated to some extent by Dr. Leonard. Now I know that I probably want to address it since I know it'll come up, and it would be something I think I would probably have to deal with at the trial, is whether Dr. Leonard meets the Kelly-Fry test. And I submit that he does. The judge, I think, agreed that he did, but just to touch briefly on the Kelly issue. To me, the Kelly issue has always been, is the evidence such that through some unproven science or some other factor, a jury is going to be overwhelmed and not have any basis to weigh and measure the expert's testimony. Here, Dr. Leonard's testimony was clear, unambiguous, and capable of the average citizen of understanding and doing the math themselves. He explained how and why those words were not Mr. Masters' words. So I, as a trial lawyer, say, okay, now you have an expert saying Mr. Masters probably didn't author this kite, which was the most compelling evidence against him. Also, it's not, I think as the judge said, not new evidence, because she said we chose to use a handwriting expert when we didn't. That's a mistake on the part of the referee. The defense did not choose to use a handwriting expert. And I submit that our brief says, and the facts state, that there was no way through reasonable due diligence that back at the time of this trial, any trial where he didn't have a Google Mini or something where he could say, hey, find me something about a linguist. That wasn't available. This is the beginning of the computer era. This is the beginning of when you can get quick access to information. There was no showing that through reasonable diligence and or any other effort that they would have known about this linguistics that now is, in fact, an accepted form, was accepted by Judge DeRee, and meets the Kelly test as well. So,
Can I just pause you there?
sure.
Even if we accept all of that, and I think there's ample support in the referee's report to say that Dr. Leonard was credible in his assessment of the authorship of the notes. What does that really get you?
Well,
because it doesn't falsify the content of the notes, and it also doesn't falsify the notion that Masters was cooperating or somehow implicated in the web of relationships. There's no suggestion that Willis testified falsely to the extent that he said that he asked Masters to write these notes. It doesn't penetrate to the actual content.
Well, I guess my argument to that would be, and I would defer to some other things I'm going to say, Your Honor, but what I would say in response to that is that I don't think that makes him the principal that he was in the case. It might make him an accessory, but it doesn't make him the principal that those are not his words, and he did not author those words, and that's not of his actions. In other words, it's not his thing. But to just, so I can jump to it, just to let you know where I would go with that, again, I'm the trial lawyer looking at this record. This is why, in my view, the cross-corroboration of Mr. Richardson and Mr. Willis is the real critical element here. This Exhibit 54, which was an unredacted copy, and we now have a redacted copy. And the most important thing about that is this is an individual who goes before the prison officials, who is going to tell them about, hey, you know what, there's getting ready to kill it.
When did Richardson make these statements?
Pardon me?
When did Richardson make?
1986.
How long since the murder was that?
Oh, about a year plus, I think. But
It was not a contemporaneous account.
But that's not why he went there. And that was the unredacted part, Your Honor. The unredacted part said he went there to speak of ongoing criminal conspiracies, of further attempts to injure or kill prison guards, number one. During the course of that, in a very, I think, he's speaking in a general sense, and I'll tell you what I know about the Birchfield murder. It's not Masters investigators soliciting, it's not Alice Lester or Ed Barbarian from the Marin County's DA's office.